Assalamualaikum warahmatullahi wabarakatuh, and hello everyone. I'm Anis Adila, and today I would like to share with you guys my case law review on cybersecurity entitled Ling and Public Prosecutor. So without further ado, let's get started. So the appellant's name is Lee Mei Ling and the co-accused name is Tan Jae. Both the appellant and co-accused was in a relationship as boyfriend and girlfriend who lived in the same apartment. The appellant had published a seditious publication on a Facebook page known as Alvin and Vivian Alfifi at 9 a.m. on 12 July 2013 in an apartment known as Complex Mutiara in Kuala Lumpur. And the alleged seditious photograph was a photograph containing the halal logo with heading, Selamat berbuka puasa dengan Pak Kute, wangi enak menyelerakan, as well as the words underlined by the prosecution in the annexure to the charge. In the caption, they wanted to introduce their own way to promote One Malaysia by exchanging the foods between races in Malaysia during Hari Raya Aidilfitri. And they did mention about the right to taste and eat any local foods without concerning about the race and religion as well. Next, SP9 testified that the photographs were recovered from Samsung laptop EXH19, which belonged to Tan Jae. And then SP12, which is the complainant who was attached to the Bahagian Kandungan Komunikasi dan Perkhidmatan Pos, had conducted a surveillance on website, and he saw through his computer that the Facebook account showed two individuals with the words Selamat berbuka puasa with Pak Kute, which contained halal logo at the bottom of it. And SP12 then reported the matter to MCMC, which is Malaysian Communications and Multimedia Commission. Next, SP18 from MCMC had investigated the complaint, and he was able to trace the Facebook account, and he found out that the Star Online had conducted an online interview with an individual who was the owner of the Facebook account, named Alvin Tan. And then the SP6, which is the Star Online editor, gave SP18 the phone number of Alvin Tan. And SP18 then contacted Alvin Tan, and he asked Alvin Tan to come to MCMC to have a statement taken. Then, Inspector Silan, or SP13, had seized from the apartment rented by Tan Ji, and among the items seized was a notebook Samsung 19. And the notebook Samsung P19 was actually analyzed by SP9 from MCMC, and he found out a few photographs kept in the file named Bakute PNG, which showed Tan Ji and the appellant with the caption stated. Next, the appellant filed the present appeal against the decision of the Learned Sessions Court Judge, or SCJ, who found the appellant guilty for an offence under Section 4, Subsection 1, Clause C of the Sedition Act 1948 and sentenced to an imprisonment term of 5 months and 22 days from 27 May 2016. And then on 10 April 2018, the court heard the appeal and dismissed the appeal on conviction, but substituted the sentence of imprisonment with a fine in the sum of 5,000 ringgit Malaysia in default imprisonment of 6 months. And yes, the appellant and Taji were charged under Section 4, Subsection 1, Clause C of the Sedition Act 1948 for publishing a content with seditious tendency as stated in Section 3, Subsection 1, Clause E, which is to promote the feelings of ill will and hostility between the races or classes of the population in Malaysia, and read together with Section 34 of the Penal Code, which means that they were jointly charged with a common intention. So now, let's move on to the judgment of the case. So, as I mentioned earlier, the appeal on the sentence by the prosecution is dismissed, and the court invoked its inherent power to set aside the sentence of imprisonment and substituted it with a maximum fine of 5,000 ringgit Malaysia in default 6 months imprisonment. So next is the issues of the case. So the issues of the case are whether seditious statement published by appellant, whether impugn statements seditious, and whether imprisonment sentence appropriate. Now let's move on to the last part of the law review, which is analysis and critique. So, as I mentioned, the appellant posted a photograph of her and the co-accused, which is her former boyfriend, on Facebook with the words Selamat berbuka puasa with Pak Kute, which contained pork, and there was actually a halal logo at the bottom of it. And of course, I disagree with the action of the appellant because the appellant should not commit such offence as it could promote the feelings of ill will and hostility between the races or classes of the population in Malaysia. And in fact, SP2, SP3, SP4, SP8, and SP12 had expressed their anger, frustration, hurt, and regret towards the publication posted by the appellant. Next, the court considered the testimonies, although no one actually saw the appellant uploaded the greetings on Facebook, and the court was of the opinion that the publication has a seditious tendency. And yes, I strongly agree with the consideration and opinion by the court because the offense committed by the appellant and co-accused is actually something that should not be taken lightly. It should not be taken for granted because it could cause the feelings of hatred between races in our country, and it could as well promote the feelings of ill will and hostility. And next, in the midst of the trial, when the case was adjourned and resumed, Tanjei had absconded. Of course, I disagree with the action of the co-accused Tanjei for being absent until the conclusion of the trial because it is clearly an irresponsible action. Tanjei wanted to escape from the sentence by the court, and he seemed so irresponsible as he did not want to pay for the offense committed by him, and he left his former girlfriend, Ling, to face the sentence by the court alone. Next, the prosecution further submitted that the term of imprisonment meted out on the appellant of 5 months and 22 days was not deterrent enough to prevent similar offence being committed by others. So yes, I agree because the offence committed by the appellant was indeed a serious offence which could promote the feelings of ill will and hostility between races in Malaysia. And let's say if the appellant was just sentenced to the term of imprisonment without being charged with a maximum amount of fine, and I think that she will have the thought that such offense is not a serious offense, and she could somehow commit the offense in the future. And of course, it is to prevent from other people committing such offense as well. Next, the appellant and Tanjai were charged under Section 4, Subsection 1, Clause C of the Sedition Act 1948 and read together with Section 34 of Penal Code. So of course I agree with it because the Act defines sedition itself as it qualifies the publication as having a seditious tendency to promote the feelings of ill will and hostility between races in Malaysia. And as for the Section 34 of Penal Code, both appellant and co-accused should be liable. They should be responsible for that act in the same manner as if the act were done by themselves alone. And last but not least, the court would temper justice with mercy by taking into account that the appellant was a first offender as far as the charge was concerned, by setting aside the imprisonment sentence and substituting it with a maximum fine of 5,000 ringgit and default 6 months imprisonment. Yes, I agree with the sentence by the court. The offence which defined in Section 4 of the Sedition Act may attract a sentence of up to 3 years imprisonment and or a fine of up to 5,000 ringgit Malaysian. Yes, I personally think that it is reasonable because the appellant has been charged with a maximum fine, and it could actually avoid from the appellant, and it could prevent from other people to commit such offense in the future. And because people may have learned from the case of Ling who had been charged with a maximum fine. So that is all from me. Thank you so much for lending your ears, and thank you for watching. And I would want you to do me a favor by hitting the like button down below, and please share with your friends. Okay, thank you so much everyone, and I wish you a good day.